Did you know that 72 jurisdictions around the world criminalise adult, consensual, same-sex activity, and the majority explicitly criminalise sex between men? Almost half of those jurisdictions are within the Commonwealth. The case was QT against the Director of Immigration of Hong Kong. It was a pro bono project relating to a legal challenge by a same-sex spouse in Hong Kong against the Director of Immigration. For background, QT was a British national, and in 2011 she entered into a same-sex civil partnership with her partner, SS, in England. Later that year, the couple moved to Hong Kong, where SS had an employment visa. After making a series of unsuccessful applications for a dependent visa, QT challenged in court the decision of the Hong Kong Director of Immigration refusing her application. QT lost her first case, but was successful in the Court of Appeal, who overturned the Court of First Instance. The Court of Appeal held that the reasons advanced by the Director in support of his policy were not logically connected to the aims it was stated to serve, namely, 1. To encourage persons with needed skills and talent to join the workforce in Hong Kong, accompanied by their dependents, and 2. To maintain a system of effective and stringent immigration control. I worked closely with other lawyers both inside the Hong Kong office and from other firms across Hong Kong to draft our application in support of QT. We argued that the policy affected our ability as multinational organisations to recruit the best LGBT talent to work in Hong Kong. Following QT's success in the Court of Appeal, the Director of Immigration appealed that decision to the Court of Final Appeal, Hong Kong's equivalent of our Supreme Court. But QT was successful in the Court of Final Appeal, and the Director's appeal was dismissed. The Court agreed with the Court of Appeal there was no rational connection between the Director's stated aims in pursuing the existing policy and the actual policy itself. In fact, quite to the contrary, the Court held that the policy clearly ran counter to the first stated aim of the Director, encouraging talent to come to Hong Kong. As that talent could clearly be homosexual, just as it could be heterosexual. The Court also noted that the Director's policy was itself inconsistent, as its department had granted dependent visas in the case of foreign contracted polygamous marriages, e.g. more than one wife or more than one husband, whilst denying foreign contracted same-sex marriages, 2 men or 2 women, even though neither is recognised under Hong Kong law. The judges in the final Court of Appeal did pick up on some of the reasoning that we raised in their final judgment, so whilst we may not have been there on the day, we were clearly present in their minds. I was incredibly proud to be involved in this case, both personally and on behalf of Herbert Smith Freehills. Human rights are not something that we can be complacent about. We have an obligation, each and every one of us, to not only defend the rights that we already have, but champion and push minorities' rights forward, and the LGBT community is absolutely no different. Whilst you may not think that this is your fight, it's everyone's fight, because one person's human rights are all of our human rights.